Ready? Start. The main ground of challenge in the writ petition is that without determination of the actual market value of the land, the collector has proceeded merely on the basis of circle rate prevalent for residential plots and determined the deficiency in the stamp duty. According to the learned counsel for the petitioner, the said property area, of which is said to be 134 hectares, has been purchased to increase his holding, considering the fact that the adjoining land is that of the petitioner where cultivation etc. is being done by the petitioner. It is also admitted that the said plot is a gaddha, that is a ditch, and therefore cannot be used for agricultural purpose in its present state. The contention of the petitioner is that the plot in question is surrounded by agricultural property in which agricultural activities are going on, and no abadi is there in the vicinity. However, one boundary wall of the roadway stand is there, but that alone cannot be a determinative factor for treating the property to be residential. Further contention of the learned counsel for the petitioner is that the collector has relied upon a report dated 24th March 2007, which is said to be a prior to initiation of the proceeding under Section 47A of the Act, and therefore the Commissioner erred in law in relying upon the same. Further contention is that subsequent spot inspection report submitted by the sub registrar dated 24th January 2008 clearly mentions that the property is agricultural, and therefore the order of the collector treating the property to be residential cannot be sustained, as the same has been held to be so without any basis. The matter was carried to the commissioner, but the commissioner also affirmed the order of the collector without interfering with the same. The point for consideration before this court, the point for consideration before the court is that the property in question, which is held by the collector to be a residential potentiality, is on the basis of report dated 24th March 2007. But the subsequent report of the sub-registrar dated 24th January 2008 has given a finding that the property in question is agricultural. I have heard Shri Pradeep Kumar Rai, learned counsel for the petitioner, and the learned standing counsel appearing for the state. In my view, the provisions of section 47A of the act clearly mandates that either suo motu or upon same report of any other authority proceeding can be initiated, and the collector, after issuing notice to the petitioner, can proceed to determine the market value of the proceeding in question for determination of deficiency in the leviable stamp duty. This court, in the case of Ram Khelawan versus State of UP, reported in 2005 RD 511, has clearly held that for the purpose of determination of market value, same principle has to be adopted as for determination of payment of compensation to the landholders under the land acquisition proceedings. It is wholly irrelevant whether the said property has been recorded as agricultural in the revenue records or not. अगर आपको वीडियो अच्छी लगती है तो लाइक शेयर चैनल को सब्सक्राइब जरूर करें और बेल आइकन को दबाना ना भूलें ताकि हमारे सभी लेटेस्ट वीडियोस और अपडेट्स की जानकारी आपको समय समय पर मिलती रहे। थैंक यू।